Um, for those that don't know me, my name is Ron Jung. I've been practicing in real estate law as well as business law, emphasizing litigation in both areas for about 31 or 32 years now. I lose track. And so I'm also on the Real Estate Section Council for the CBA, and I attended their video conference on remote closings, which was on Tuesday. It was very helpful. There's a lot of information out there, and I'm going to try to touch on some of it. There's some areas that I really don't know about. Every day, something new pops up. And so at the end of this, I think it's important to have a free exchange of conversation just so everybody can share their most recent experience with the group. I think the collective is always a good way to go. As part of the Real Estate Section Council, there's actually an emergency provision that allows the Section Council as well as the officers of the CBA to pass approved forms for real estate contracts. Usually the commission adopts those. And so we actually did do that. And we passed the COVID-19 addendum, which typically under this slideshow, if I clicked on this, it was supposed to bring it up, but it doesn't. So luckily I anticipated some problems, and the next slide. So the document is a 2-page, it's really short, and it's available on the Colorado Real Estate Commission's website under contracts. Actually, it's under the addendums to the contracts. And so if a broker is going to address issues pertaining to COVID, they would have to use this form. Lawyers obviously can draft their own provisions, but it's really a 2-section form. And so I'm going to talk about these sections separately. This is a larger blow up of section 1, which if you have the form, and by the way, the actual form is included in your PDF packet. So you can look at that as well. And that has blanks to fill in the names, etc. So this is the section 1 of that approved form. And it kind of follows, I don't know if very many people are aware of force majeure. I'm going to talk about that later on, but it sort of follows the requirements for that kind of a situation, except that the notice provisions are different, and I think, as I'll describe, a little bit lacking. So this, in essence, talks about what can happen in terms of delays by settlement service providers. And those are, they've listed examples as lenders, appraisers, title company, surveyor, owners association. I would also add the obvious one of inspection companies, and anything that's within the due diligence phase of the contract would be considered a settlement service provider. And so the way this section reads is that if you're having some delay because of a settlement service provider either has a delay or they suspend service, as it states here in the section, then you can have what they call in the form a delay period. Now it's interesting, in the form, delay period is capitalized, so you would think it was defined somewhere, but it's not. It's fairly self-explanatory, delay period, but it doesn't really give any information if you were going to have to provide notice of default, things like that, as to when a delay period ends or starts. It has, it's pretty obvious when you get a notice from a settlement service provider that they're going to have to extend their performance. That would be the beginning of the delay period. And they kind of describe it here a little bit. But as we'll get into in force majeure provisions or impossibility considerations, one of the big issues is notice to the other party. So, when you're dealing with contracts like this, obviously written notice would be recommended, if not required, if we were rewriting this. And by the way, this isn't a criticism to the group that drafted this. They were under the gun. I think it got drafted over a weekend, if I'm not mistaken. So it serves the purpose. But I would make some suggestions as to additions if you're representing buyers or sellers and they have to use this provision. I think that there needs to be more notice. So once you are aware that there is a problem or an extension, I think that you ought to send written notice that there is a delay period beginning, and in case you have to go under theories of impossibility or force majeure, you need to describe what that problem is as best as you can. And obviously, when you're dealing with the buyer and seller, they're trying to cooperate. They want the deal to, go through. So there's no real reason not to be transparent. Then there's a provision here at the end that says if the buyer and seller is prevented from closing within blank days of the original closing date due to one of these delays, the contract terminates, and pursuant to section 25.2, the earnest money would be returned to the buyer. So I do believe it's a good idea to fill that out with a certain number of days, but I also think that you may want to have an extra provision that says that if that the parties can obviously at that time of expiration, they can amend and decide that they're going to go ahead and extend that termination provision. I think that's important because if you're, let's say your inspector gets the inspection done and you're up upon this deadline for the contract to terminate, the parties are going to want to do an amend extend so that they don't run up on this deadline. And if you notice at the very end of this provision, there's nothing in the agreement that prevents an amend extend in writing. So if you were to fill in, let's say 14, 15 days from the original contract closing date and then don't pay attention, you can end up having a contract termination that nobody really wants or anticipates. And so it's really important that there be notice both of the beginning, I think, of a delay period as well as the ending of a delay period in order to be able to enforce the terms of the contract. If you can keep your questions in your minds, like I said, we're going to have a discussion period toward the end of this presentation. And so I'm sure people are going to have a bunch of questions regarding these provisions. So the second part is related to quarantines. And this springs into effect if if either of the parties are quarantined and therefore unable to perform under the contract. And again, they use the term delay period. Again, it's undefined in the rest of this agreement. This provision, I think, also requires notice. It actually says that you have to provide notice of quarantine to the other party, but it doesn't indicate that you have to provide notice that the quarantine has been lifted. And if you don't have that second notice, then the deadlines aren't going to spring back into effect and you won't be able to determine what the delay period is. There's no similar termination period that you would fill out in this section 2. And I think that's important. You may want to add that if you're representing a buyer or a seller, because if a quarantine lasts longer than the parties anticipate, they may want to do something else with the property or with their funds. They may want to close a loan and move on. So without a termination deadline in this section, theoretically, the quarantine could delay performance of the contract indefinitely. And I don't think anybody really wants that. Again, if you do have a deadline, like in section 1, you're going to want to revisit the contract before that deadline to see if you want to extend it. But without such a deadline, there's no way to terminate the contract if you're under this quarantine provision. This provision also contemplates remote closings, and we're going to talk about that in this presentation. And so, and it talks about that the quarantine party must make other accommodations if they're not going to be able to perform. So that's not necessarily consistent with the language up above where there's going to be a delay. So I think a seller, again, has to communicate in writing as to what they're willing to do, what the accommodations they're willing to make, so that they don't end up in a breach of the contract. I think these provisions are great if everybody's cooperating and communicating, but as you all know, when there's a potential breach of the contract, then you've got the earnest money comes into play. And just as a note, the liquidated damages clause, which is typically the one that's selected in the standard form contract, doesn't apply to sellers. It's kind of written, and it's not necessarily fair in my opinion, because specific performance in the form contracts always applies as a buyer's remedy for a seller's default. So you may want to just take a look at that. I typically suggest an amendment to that, which usually gets turned down. But if specific performance is a remedy and the buyer is looking at a seller default, they're going to pay attention to these sections, and it can get costly. And so again, put everything in writing, put all your dates in writing, so that if you have a dispute under these 2 sections, you've got some proof. So separate and apart from this addendum, you've got some areas of law that I think are going to be pertinent to all kinds of real estate issues, not only contracts to buy and sell, but to leases, possibly foreclosures. We're going to get into some of that later on in the presentation. Force majeure clauses in a contract, you'll see those typically in construction contracts where there are deadlines for performance and exceptions to those deadlines if something happens. There are no force majeure contract clauses in the standard form real estate contracts. And in Colorado, you might be forced then to argue impossibility of performance if you don't have one of these clauses in the contract. And here's an example of one of the clauses that appears in some leases, construction contracts. I didn't check the deed of trust form in Colorado, but a lot of mortgages have these clauses in them. But basically, if there is an event of force majeure to excuse performance, it's something that suspends performance. It doesn't terminate performance. And there's also some requirements. that you have to provide notice and detail of what the problem is and indicate what you're going to do to try to correct whatever the problem is. So this is just a typical example. And by the way, this article here that's cited, it's got a Westlaw site, has some really good contract language throughout, and it's got different examples. So for instance, one example of the definition for force majeure is here, and this is kind of the long form. And it talks about what we all remember from law school probably, you know, acts of God, strikes, lockouts, disputes, civil disturbances. It also talks about and includes government interruptions or court orders, and the inability to comply with statutes, ordinances, other governmental authority. And that's going to come up, I think, in practice now, and we'll talk about in a minute, clerk and recorders that are not open or that are just recording based upon e-recordings or mail. So, and for instance, it may be difficult to get a building permit. There may be some engineering delays that would result in the inability to get a building permit. So all of these can come up, I think, and this virus, I believe, would be a force majeure. I can't imagine a court that would not find it something akin to force majeure that's unexpected. Unexpected consequences kind of comes under the impossibility of performance area, which we'll talk about here in a minute. Here's a force majeure definition. It's a little bit of a short form. It doesn't list out all the possibilities. And it's basically any cause that's not reasonably within the control of the party claiming suspension. And if you go back to the previous definition, that makes sense. All of the examples that they talk about in the previous definition are items that are not under the control of the person that's claiming to be affected. And so there's a requirement that you exercise due diligence to try to overcome the force majeure consequences. And once again, all of these notices need to be in writing. That's not in this slide, but in the case law and in the restatements, notice is a big deal. Both sides have to communicate as to what the suspension due to force majeure is going to mean. I think the parties can still negotiate if they want a termination, but that doesn't come automatically. It's a suspension or a delay provision. So that brings us to the contract defense of impossibility of performance. Once again, these are concepts that if you practice contract law, you'll remember, or you'll remember them from law school if you don't. But impossibility of performance has to be an unanticipated circumstance. It can't be that it's just a bad deal and that you're not going to make as much profit. And so you allege impossibility of performance. It has to be something that was not foreseeable. And as you can see in this definition, this comes from the case of Ruff versus Yuma City Transportation Company. And the top bullet point is the definition of impossibility of performance, but these are all, the bullets below it are also provisions or qualifiers in that case. So as I said, a change in economic conditions is not a basis for rescission of a contract. changes in competition or your profit. If, you know, for instance, materials increase, that's not an excuse to excuse further performance. And the fact that the value of that the bargain has decreased is not an excuse for non-performance. But if, like the coronavirus is something that nobody has anticipated or contemplated, if that causes an impossibility of performance, I think that you do have a legitimate argument for termination of a contract. That's instead of force majeure where you're suspending performance. I think this could result in termination. And I think this is going to come up in leases. I think that tenants are going to argue impossibility of performance, and we'll go on to that a little bit later. But it's going to be a real harsh ruling. And I suspect that there are going to start being cases around the country, first impression, where they're going to say that, yes, the coronavirus creates an impossibility of performance, and then would let tenants out of the lease, or possibly, you know, cause lenders to have to go through a bunch of hoops. And on the other side, when we get to talking about landlord-tenant issues, it's going to, if that in fact is how the law is going to shake out, it's going to cause landlords to want to be cooperative and negotiate extensions or forbearances, so it doesn't go to court. On the other hand, if somebody really wants out of their lease or their contract, whatever it is, it may be better because of this theory of impossibility of performance to let that person out and move on. You want somebody who's going to pay rent, who's going to actually go through with the contract to purchase real estate or whatever the contract is. You're going to want that to be performed rather than hassle with someone who maybe doesn't have the ability to perform any longer. Next thing I want to talk about is the race notice statute, which has not been changed or suspended or anything like that. The statute's at 38-35-109, and in essence, it just says that no unrecorded instrument shall be valid against a recorded instrument that's prior in time. The actual language is here on the slide. If you remember what a race notice statute means, it's that if you've got a party A who is transferring a deed to property to party B, and then they subsequently sign a deed to party C, it's whoever gets recorded first has superior title. And there are a bunch of different exceptions. I don't know if you remember in property class, there were probably 20 different A, B, C, D, E examples that were given. And I don't need to go through all of those. But so when you're going to record a deed now, right now anyway, and there's a list that was provided by, I think it was Fidelity Title, that's in the PDF materials of the current status of the clerk and recorder's offices. But if you mail in your deed, you're not going to know exactly when that gets picked up by the clerk and recorder's office. If they're completely closed, it's not going to get picked up and recorded until they open again. And so the best case scenario is to use e-recording. However, that's not available to individuals. You have to be a commercial submitter and you have to have an account with that particular clerk and recorder. My guess is, you know, any law firm, even if you're a sole proprietor, you should be able to open up a commercial account. And so right now, if you don't e-record your deed or your transfer or whatever you're recording, which will then give you a date and time stamp back, I think you're possibly falling below acceptable standards of care. And it's a really tough time at this point. So if clerk and recorders get a bunch of recordings in the mail and they open again, and so they start recording those, they're not going to have any idea of the order in which they came in. And they're not supposed to look at the dates of the documents. They're supposed to file them in the order that they receive them. So as it indicated here, county commissioners have the authority to decide if a county office will remain open. And that includes whether they're going to receive mail documents. There are some counties that have drop-off boxes. Some counties have suggested that the voter drop-off, the ballot boxes be used if they don't have a drop-off box. And so there's some material that I included in the PDF, again, that talks about what the different clerk and recorder's offices were doing. It's a little bit old, it's a couple weeks old. And so the websites here that I've listed are also good sources to check, and you can check the particular clerk and recorder's office to see how they are handling the remote or the e-filings. This is a slide that is a copy of the Fidelity National information that I included in the PDF packet. This was supposed to work so that if I double clicked on this, it would be readable, but it's not working. It just brings me to the next slide. So we'll go to the next slide. And we're going to talk about the remote notary. That's a temporary rule. So one thing that all the commentators so far have cautioned on remote notaries is that we should all check our malpractice coverage because some policies have exclusions for transactions involving remote notaries. I checked my policy and it doesn't, but apparently there are some policies out there that do have exclusions. And so the suggestion has been, if you have one of those policies, to contact your insurer and see if they'll modify the exclusion based upon these temporary rules. So this remote notary rule 5 will expire April 30, 2020, unless it's extended. And I don't know if you're aware, but there have been remote notary legislation in the last 2 or 3 years that haven't passed because they've had a bunch of different issues regarding privacy and record keeping. Some of the entities that were promoting the legislation, I think, were doing so because they wanted to get people's information and they were going to sell it for marketing purposes. So this rule is in effect right now. The essence of this rule, and you can look at it, it's fairly lengthy in the materials, but these are some pertinent points. It has to still be a Colorado transaction. So the notary has to be physically present in Colorado, and the signer has to be physically present in Colorado under this rule. They have to communicate in real time by audio video communication. So something like what we're doing now. And there has to be the ability for the notary, and if there's a requirement for an identifying witness, to see and hear each other without interruption or delay. Then there's also the requirement that the recording of the video needs to be available for long-term storage. And I believe right now, under this rule, they have to store it, I think it was for 6 years. I should have that here. So when you're having one of these conferences, and it's being recorded, the notary has to be able to verify the identity of the signer and of any identifying witness. He has to be able to confirm, he or she has to be able to confirm that each signature to which the notarial act relates was placed on the record during the recorded session and not at some earlier time. They have to be able to verify that they're viewing the same document at the same time. And for identification, the signer may be personally known to the notary. The signer may be identified by a remote presentation of a government-issued identification, and the data contained on the identification matches the representations. This may not have to be a photo ID if it meets statutory requirements, but most statutory IDs will have photographs. And the statute that's referring to is CRS 24-21-507. The signer also may be identified to the notary by a credible witness who is personally known to the notary and whose identity is confirmed by a statutory ID, and who swears or affirms that the signer is who the signer claims to be. After the signer has signed the document, either manually or digitally, the signer must transmit the document electronically to the notary on the same date. So one commentator has said, don't start this process at 11:57 p.m. The recording of the remote notarization session must be stored for 10 years. And the Colorado Secretary of State website has a good page on remote notarization under, it's called Notary Public Facts. And they do address some of these issues on this temporary rule. I also want to talk a little bit about title insurance before we move to evictions and foreclosures. Right now, there was a person representing title insurance companies on Tuesday, but right now underwriters are continuing to provide gap coverage to transactions, even though the clerk and recorder's office is temporarily closed. So that's a big deal. And the gap coverage is going to be expanded significantly if documents can't be filed in a timely or recorded in a timely manner. So that's good news. And then there are numerous requirements for the title insurance companies in order to provide that gap coverage, and they're not consistent, but they're fairly complicated. The other thing I'm not going to really go into is are the lending requirements. And lenders are, they're adding requirements in order to close, and they're fairly specific to each lender. And there are some programs out there, federal programs that set forth the parameters of those requirements, the minimum parameters. So it's a fairly complicated topic, and if you've got a transaction, you're just going to have to work with a specific lender to determine what those requirements are. So now I want to talk about evictions and foreclosures. And there's an executive order 31, and these are just designed, the order is just designed to kind of alleviate some of the pressure on folks. I don't think it's designed or thought to solve any issues, but it's just designed to help. And so the first part pertains to public trustees. And as you can read there, 3838-102 concerns deadlines for recordation of a notice of election and demand for sale. And you can read these as well as I can, but they're all pertaining to foreclosure events with the public trustee's office. And so there are provisions that this order will expire April 30 to 2020 unless it's further extended. So these provisions in the actual order, and the order is part of your materials in the PDF that I attached or that you have. So you can, if you're into the foreclosure area, you can check these specifically to see what relief they provide. This order also provides that county treasurers may suspend or waive delinquent interest through April 30, 2020, which is incurred under that statute 39-10-104.5. So that may help a little bit. I don't think just the interest is probably not going to save the day. I want to talk a little bit about just the practicality of what's going on in the leasing world. And Kyle, if there's a way for you to unmute Rick Reichstein, sorry.
Sure, let me give that a try. I believe it's Rick here.
Okay.
All right.
Rick's primary practice is in commercial leasing. He works at Faegre Drinker. I like to kid him and say he was the original Faegre Drinker, but it's probably a bad joke.
And Rick, I have you unmuted. Can you hear us and can you respond? Let's see. He's having a little issue getting his audio going. Let me,
He thought he might be on his phone.
right, let me figure out. Looks like he's. Rick, I think I have you unmuted now. Can you hear us okay? Oops. Try again. All right, Rick, I think I have you
unmuted.
Okay, there we go.
Is that it?
Yep, we can hear you okay.
Hey, Rick.
Thanks, Kyle. Thanks, Ron.
Of course.
As Ron mentioned, I'm a partner at Faegre Drinker, Biddle and Reith out of the Boulder office. My primary practice is real estate. I do a lot of commercial leasing, as Ron indicated. And he asked me to kind of weigh in on what I'm seeing as far as what's going on in light of the COVID situation in leasing. Mostly right now, what we're seeing is tenants asking for some sort of a relief, whether it be in the form of an abatement of rent, a deferral of rent, or something along those lines. A few tenants have flat out said, hey, landlord, we're just not going to pay. And so, you know, my guy, as far as from the landlord side, what we have taken the tact is to treat each one individually. The first thing that I tell landlords and or tenants is you got to look at your lease. Ron touched on force majeure. Most well-drafted leases exclude from force majeure the payment of rent or any money. So that's not an avenue that the tenant's really going to be able to utilize to get any redress under their lease. Ron did talk about impossibility. That may rise. I haven't seen it yet, but that may come to fruition. We'll have to see. And then as far as what tenants are getting these kinds of relief, mostly it's in the retail context. There is some industrial tenants that are getting some relief as well. Those are mainly ones who have like showrooms. Think of your floor companies, your granite wholesalers, and that kind of thing. Office tenants, right now, I'm not seeing a whole lot of office tenants getting any traction with looking for any relief from the landlords. When we look at doing any kind of a relief for a tenant, one thing the landlords need to do is double check their loan docs. Oftentimes on a non-recourse loan, there are a couple carve-outs that can bite them. One would be the admitting in writing that the borrower is unable to pay their debts when they're due. So a landlord doesn't want to go to their lender and say, hey, look, my tenants aren't paying me, so I'm not going to be able to pay you. That will usually trigger that recourse to the guarantors. And another one is sometimes an unauthorized lease amendment gets treated like a transfer. Oftentimes in loan docs, the lender will give the borrower some leeway to do certain types of lease amendments and transactions where they don't have to get their consent. If it becomes a situation where you don't have the ability to do what you want to do, say grant a rent relief or something like that, and the lender treats that as a transfer, that again will trigger that recourse to the guarantor. So you need to double check those very, very thoroughly. As far as the nuts and bolts of what we're doing is on the relief side, most of the time abatement is probably like the last resort. That's the last one that a landlord wants to get to. It's usually probably going to be somebody who's a real big tenant. Think of your Best Buys, that kind of thing. Or a mom and pop who absolutely is not gonna make it unless we do something drastic. So the most common course would be some sort of a deferral. I've seen them be for a specific time, say a 3-month period, or maybe it's we'll defer you until the earlier of the lifting of any applicable state or municipal stay-at-home order, or in a restaurant context, maybe the lifting of the applicable state municipal dine-in restrictions, or a 3-month period. And then that rent that gets deferred gets taken out to the start of next year, and the tenant pays that rent plus their current rent at that time. Landlords are pretty reticent to want to have a tenant get full rent relief. Base rent is about all they'll be getting. We want them to still keep paying operating expenses and those kinds of things. And then when you're papering this deal, a couple things to keep in mind. You want to make sure for bankruptcy purposes that you expressly state in there that the repayments that the tenant's going to make of that deferred rent are made in the ordinary course of their business, and that they're also getting benefit in the amount of that additional payment that they're making, so that later on it doesn't get unwound if for some reason they go into bankruptcy. It's also a good idea to have an estoppel in there to make, to say that the landlord's not in default of anything, that the tenant's going to comply with CDC requirements, that they hold the landlord harmless of any issues if there's a COVID problem or something at the premises, and that they're going to waive any frustration of purpose or impossibility, to Ron's point earlier. And then the last thing we try to do with tenants is to steer them to find some sort of funding, whether it be through the CARES Act or a small business association loan, and then also ask them to make a claim on their business interruption policy. Real quickly on that front, I'm not an insurance expert, but from everything I've seen and all the stuff I have read, it appears to me that contagions are usually excluded from business interruption policies, so they may not get a whole lot of traction with that. I know there are a few states out east, I think New York and Ohio still are pushing to have insurers cover for the COVID situation, even though they're expressly excluded. That may trigger some sort of constitutional issues with the contracts clause, but that's way beyond the scope of what I know. So those are Ron, kind of what I'm seeing and how we're treating those types of situations.
Well, thanks, Rick. That was real informative. People may have some questions when we open it up. And yeah, this impossibility of performance is going to be an interesting one if it goes through the courts. So I have two more slides. This is on the Colorado website, State of Colorado website, and it's included in your materials in the PDF, and it's just an assistance program resource list. Again, I can't click this to make it bigger, so but you'll have to be able to look at it in the packet. And then lastly, again, I can't enlarge this slide, but this is the executive order, the current executive order to stay at home. I included that with your materials just in case somebody wanted to look at it to see what it said. It's kind of what gave rise to all of the concerns that we've been talking about, or maybe it didn't give rise to it, but resulted from the virus that gave rise to it. So I had originally planned to talk about an hour, which we're a little under that, and we don't necessarily need to go all the way to 1, but I did want to spend some time and open it up to folks to share their questions, answers, collective experience in this time of confusion and new ideas and new circumstances. So Kyle, can you do that?
Yeah, so currently everyone who's on here is muted. If you are able to unmute yourself, the easiest way to do it is just tap your space bar and that'll unmute you. You can also use the chat at the bottom center of the Zoom screen to send a quick chat question either to Ron or to the group. So it's up to you how you'd like to do that, but that is an option. And then you can just join in. Chat might be helpful just because then we aren't all talking over each other, but if you just want to join in, please feel free. And I guess, Ron, if you have any other things to cover while we wait for people to join in, feel free, just in case anyone's shy to come in first.
Well, I'm still figuring out this.
Hi, Ron. This is Judge Labuda. Are you able to hear me?
I can.
I'm wondering if I understood correctly with the slides that a notary would not be able to notarize something for a real estate transaction by video notary if the purchaser or seller is presently outside the state of Colorado. So unless that person comes back to Colorado and is physically present, they cannot have it notarized by the video audio. Is that correct?
That's correct right now. There are some other programs that are out there like Mars and other things that I'm not really familiar with, where they might be able to figure out how to do an interstate transaction, but under this Rule 5, it's all Colorado.
Thank you.
Uh-huh. Have anybody had landlord-tenant residential disputes arise yet?
Ron, this is Stephen Jensen. I have a question about the period of time you're supposed to keep the records of the remote notarization. You said 6 years, but what kind of records are you supposed to keep? Video or?
Yeah, it's my understanding that it's a copy of the video, and it's actually 10 years. I saw that in my outline after I misspoke and said 6. So yeah, that's a big issue. And that's also a big issue or concern that has thwarted adoption before the virus in the several incarnations that were presented.
Thank you.
Oh, you're welcome.
And Ron, this is Kyle. A question came in via chat. It's seems like good force majeure clause might help defeat impossibility claim. I guess they were just looking for a comment from you on that.
Yeah, I mean, I think they're different. A force majeure clause is again going to suspend performance, whereas impossibility could terminate an agreement. So I guess if you've got the suspension of performance under a force majeure clause, that could render impossibility of performance harder to prove, because you've got an extension of time in order to get through whatever it is, get through the virus, let's say. And yeah, so I mean, impossibility focuses on what's foreseeable and what's contemplated by the parties. I don't know if that answers your question.
And they'll chime in if not. And then we have another notarization question. It says, concerning the remote notarization, understandably, a Colorado notary can't notarize for a person in California, but would a Colorado court accept a remote notarization from a California notary for a California resident?
So you're probably going to get outside of my knowledge here pretty quickly, but I don't believe so. There are some states that have adopted remote notarization already. And in those states, I think, yes, probably you could. But Colorado doesn't have that yet. And so right now, Colorado doesn't really, is my understanding, accept remote notaries from other states.
And Ron, I'll follow up on that because next Thursday we have a remote notarization CLE presented by Kurt Hofgaard and Marty Moore. So within a week, they should have, I won't say all the answers, but most of the answers, hopefully everyone's looking for. So definitely check out next Thursday's CLE if you have notarization questions.
Yeah, great.
Ron, this is Judge Labuda again. There had been some requests from members of the bar to the bench to place a moratorium on the filing of evictions, not the moratorium on tenants being evicted, but upon the filing of evictions. Can you tell me what, if any, pros and cons you identify to that process?
Yeah, I mean, I don't think it's really fair. Rick and I talked about this before the meeting. I mean, that allocates the loss entirely to the property owner, the landlords. And like I said, I don't know if that's fair. Same thing with impossibility of performance. If that goes in the tenant's favor, the landlords are really going to not have much of a remedy. And I don't know the distinction between filing for an eviction or actually evicting them. Obviously, you'd have to file, but aren't the evictions right now in most of the jurisdictions on hold?
Yes, the evictions themselves are on hold. As I understand the request of placing a moratorium on the filing, and I understand this has occurred in the 1st and the 9th judicial districts, that the request is made in light of all of the filings that might occur within, say, the first week that the courts are back to normal operations, and then the number of people who would need to obtain representation, particularly if they're retaining attorneys pro se or through Boulder County Legal Services. And I'm not sure really what the implication might be on the courts, I'm thinking it might be a bit overwhelming if everybody files the first week that we're back to operations of hearing non-essential matters. But you obviously have more experience in this area, as do I'm sure many of the other people on the call than I do. So I was just wondering for some insights as Judge Bakke and I discussed that.
Yeah, and I would encourage landlords, I guess, to, again, be patient and work with tenants, whether it's commercial or residential, because I think this impossibility of performance issue is a huge hammer. And so, you know, I think that gives an incentive to the landlords to take their time. Yeah, I don't know, with all kinds of cases, I think there's going to be a huge rush to file once the restrictions are lifted. And maybe it would be a good idea for you guys to let us know if there are any suggestions. You know, I can propose stuff to the real estate section council or other people if you have good ideas. But I think it's going to be hard to parse out that you have to stagger your filings or something. Nothing occurs to me.
Thank you. I appreciate that.
Anybody else have ideas on that topic? Well, we've got a new case that just came in yesterday of some tenants, students that attended CU, and summer classes have been canceled. And so everybody is basically vacating the premises. The landlord is being pretty tough, threatening court action, even though right now I don't think they can take any. And so I guess I'll be exploring the outcome of that scenario pretty soon. But you've got all kinds of issues in that scenario. You've got contribution rights among all of the tenants. They're jointly and severally liable. And so it's going to make settlement difficult because it's going to have to be a global settlement. And I think the landlord is going to be in a really bad spot to try to file an eviction and try to get a judgment for future rents in that situation. They may be chasing the wrong kind of judgment that might be difficult to enforce if they can even get it with this impossibility issue. Well, anybody else have any questions or comments? If not, I guess we can call it a day. All right. Well, thank you, everyone. And I hope everybody remains safe. And maybe if this continues for another month and I talk again, I'll have to wear a hat because I need a haircut pretty badly. So I guess that's it, Kyle. And there'll be the opportunity to get CLE that you're going to send out, Kyle. Is that correct?
I will send out the form to everyone who participated here shortly. And again, thank you, Ron, for participating. And I assume if anyone has any questions, they can reach out to you directly. And I'll put the presentation materials on the website as well with the video. So thank you all for coming in. Like Ron said, stay safe.
Bye.
Thanks, Rod.